When it comes to freedom of the press here in Canada, it is not one and the same thing as what is transpiring in America. In America, freedom of the press is given to them as a right, a fundamental right. In Canada, it's given to the people as a fundamental freedom. When we look into the Constitution Act of Canada 1982, Article 2, now remember that we have already learned that all these freedoms in Article 2 are subject to limitations. They can be limited and abridged. And when we look at Article B, we see freedom of the thought, belief, opinion, and expression, including freedom of the press and other media of communication. So right here, the freedom of the press, that it was brought forth in Article 2 of the Constitution of 1982, means that it can be subjected to a limitation. Meaning what? It means that you can't just claim under Article 2 that you have the freedom to record whatever you want in a public space. That's the operation of law that they claim in America. They claim that they have the right to film in a public space. And so some are trying to use that same right that they see operating in America here in Canada. And they claim, well, I have freedom of the press, which entitles me to film in a public area. And some are waking up and seeing, well, no, that's not the case. Some are being arrested. Some are being charged. Jumping into the international law, the ICCPR, Article 19. It reads, everyone shall have the right to hold opinions without interference. Everyone shall have the right to freedom of expression. This right shall include freedom to seek, receive, and impart information and ideas of all kinds, regardless of frontiers, either orally, in writing, or in print, in the form of art or through any other media of his choice. So this is where the freedom of the press comes out of. It continues on to say, the exercise of the rights provided for in paragraph 2 of this article carries with it special duties and responsibilities. It may therefore be subject to certain restrictions. And these restrictions include for the protection of national security or public order, or public health or morals. So it allows them to place a limitation or an abridgment, a restriction upon your freedom of the press. And they'll make up their own restriction, and they'll designate it under public order or national security. And they'll say, for the better of public order or for the better of national security, we're restricting the freedom of the press. Therefore, if you try to invoke your right to the freedom of the press under Article 2 of the Charter of Rights and Freedoms here in Canada, it's like shooting yourself in the foot. You're invoking a freedom that they can place a limitation and abridgment upon. Looking back in the Charter of Rights and Freedoms, Article 2, where we find the freedom of the press, we also find freedom of peaceful assembly and freedom of association. Now, these freedoms can also be limited and abridged. So like I said, all of the fundamental freedoms enumerated or listed in Article 2, these are all subject to limitations. Looking back into international law, Article 21 and 22, the freedom of peaceful assembly and the freedom of association. Now we see here that a restriction may be applied against these freedoms for security or public safety, for public order, for the protection of public health or morals, or the protection of the rights and freedoms of others. So both of these freedoms can be limited and abridged, and we find their expression in Article 2 of the Charter of Rights and Freedoms. So all of the freedoms enumerated and listed in Article 2 of the Charter are subject to limitation. So you defeat yourself if you try and invoke those freedoms here in Canada. The International Covenant on Civil and Political Rights, Article 9. Now listen here and see if you catch it. See if it rings a bell in your understanding. Everyone has the right to liberty and security of person. What subject are they talking about? Who are they talking about? Are they talking about a statutory creature? Or are they talking about you in your position as a man or a woman? Looking back into the Constitution Act of Canada 1982, Article 7, everyone has the right to life, liberty, and security of the person, and the right not to be deprived thereof except in accordance with the principles of fundamental justice. So we see the exact same expression, right? As we just saw in Article 9 in the international law. It says everyone has the right to liberty and security of the person. The rights brought forth in Article 7 of the Charter are available only to individuals who are standing under their full legal capacity. Only to men and women. The Supreme Court of Canada told us everyone has the right to life, liberty, and security of the person serves to underline the human element involved. Only human beings, only men and women can enjoy these rights. Everyone then must be read in the light of the rest of the section and defined to exclude corporations and other statutory creatures incapable of enjoying life, liberty, or security of the person, and include only human beings, only men and women. So coming back to Article 9, right? Reading the first sentence again. Everyone has the right to liberty and security of the person. This article of law, in the beginning of this sentence, what subject is it referring to? Well, it's kind of obvious, right? It's referring to a man or a woman. And it goes on to say, no one shall be subjected to arbitrary arrest or detention. Now, that operation of law, which is arbitrary, I've explained to you in the past couple of videos, right? What it means for them to be using arbitrary power against you. Now, no one shall be deprived of his liberty, except on such grounds and in accordance with such procedures as are established by law. So, no one shall be deprived of his liberty. They're still talking about an individual under their full legal capacity and saying that you cannot use arbitrary power against an individual to deprive them of their liberty. And just to help you a little bit more here, right? The terminology or the word liberty doesn't only bring forth or doesn't only apply to a confinement, to being placed in confinement. Liberty has a broad understanding, a broad expression of what it includes. Anyone who is arrested shall be informed at the time of arrest of the reasons for his arrest and shall be promptly informed of any charges against him. Now notice, right, that the subject or the player has changed. They didn't write here, everyone who is arrested shall be informed. They wrote anyone. They changed the subject and the player because the word anyone includes a statutory creature or a man or a woman. For example, a man or a woman can be arrested under common law for stealing, can be arrested under common law for murder or violence. So anyone includes the man or the woman. But you can also be arrested as a statutory creature and then charged as a statutory creature. That's why they changed the subject and player here from everyone to anyone to encompass or to include all capacities. Subsection 4. Anyone who is deprived of his liberty by arrest or detention shall be entitled to take proceedings before a court in order that the court may decide without delay on the lawfulness of his detention and order his release if the detention is not lawful. So when you're a statutory creature, right, and you say, I'm invoking the freedom of the press, and therefore this arrest or this detention is not lawful, and I should be released. Well, they turn around and they say, hang on a second. Your freedom of the press is subjected to limitations. And we placed limitations upon that freedom. And you breached those limitations. You broke the rules. That's why you are arrested. So therefore, you will not be released. Subsection 4. Everyone who is deprived of his liberty by arrest or detention shall be entitled to take proceedings before a court. That's called habeas corpus, in order that the court may decide without delay on the lawfulness of his detention, and order his release if the detention is not lawful. And if you've been subject to an unlawful detention, then afterwards, right, you have a right to an enforceable compensation against them. Now look at Article 10. It says all persons. So the subject or the player has changed again. All persons deprived of their liberty. Everyone has the right to liberty and security of the person. No one shall be subjected to arbitrary arrest or detention. Anyone who is deprived of his liberty by arrest or detention shall be entitled to take proceedings before a court. What does that mean? You have the right to take proceedings before a court. The Charter of 1982, Article 7. Everyone has the right to liberty and the right not to be deprived thereof. That's your entitlement. That's your right to take the proceeding. Now, in the Charter of 1982, Article 10, it says everyone. Here's the player again, referring to the human being, to the man or the woman. Everyone has the right on arrest or detention, C, to have the validity of the detention determined by way of habeas corpus, and to be released if the detention is not lawful. So there it is. You are entitled to take proceedings before a court. You have the right not to be deprived of your liberty. You have the right to challenge the validity of the detention or of the arrest by way of habeas corpus, and to be released if the detention is not lawful. And further to that, you are entitled to monetary compensation if the detention is determined to be not lawful. Now notice in the Constitution Act, Article 11, it says proceedings in criminal and penal matters. Well, who does penal matters refer to? The statutory creature, right? And so can criminal matters refer to the statutory creature. And it says any person. The subject and the player has changed. It's no longer an everyone, but it's now a person being charged with an offense under penal matters or criminal matters. And they have the right to, and they tell you what you have the right to. But what you'll notice is that the right to habeas corpus has been removed. It is no longer in operation for the person. It is only the human being that can invoke habeas corpus here in Canada to see if the detention is lawful or not, to see if the restriction of the liberty has been done in accordance with the principles of fundamental justice. Now, if you invoke Article 2 of the Charter and you stand as a statutory creature, then a limitation and an abridgment can be placed against that freedom, and you will be charged in criminal and penal matters. But if you remain under your full legal capacity, under the liberty of a man or a woman, then you have the right to invoke habeas corpus. And in doing so, you're exercising your right not to be deprived of your liberty. Because there's no principle of fundamental justice to deprive you of that liberty. The Supreme Court has already said a limitation placed against a Section 7 right will never happen. Never. So I wasn't exercising the freedom of the press. I was exercising my fundamental right to liberty. And in that exercising of my liberty, yeah, I was recording with a camera. So what is it to you? The Criminal Code of Canada, Article 794, subsection 1. No exception, exemption, proviso, excuse, or qualification prescribed by law is required to be set out or negative as the case may be in an information. So when they arrest you because you're exercising your freedom of the press and they lay an information against you and they lay charges against you, they have no obligation to tell you that a lawful excuse exists for you, that there is an exemption, a proviso, or a qualification that is prescribed by law that does not allow them to charge you. And that's the way they have it set up in their laws, right? Because we saw that anyone who is arrested or anyone being held in detention shall be entitled to take proceedings before a court. And in Article 7 of the Charter, it says we have the right not to be deprived thereof. And in Article 10, it says that we have the right to have the validity of the detention determined by way of habeas corpus and to be released if the detention is not lawful. All these operations of law rest upon our shoulders. That is why here it says that they're not under the obligation to provide your excuse, to provide your proviso in the information that they lay against you. It's up to you to exercise the right, not up to them to tell you you have the right or how to exercise it. And that's the same operation of law that we see from international law into domestic law. The responsibility is ours. But how can we exercise the right if we don't understand it? The Criminal Code of Canada, Article 126. Every person who. Now the word person here in the Criminal Code has been redefined. It's redefined to sometimes include statutory creatures or men or women. Now every person who, without lawful excuse, contravenes an act of Parliament by intentionally doing anything that it forbids or by intentionally omitting to do anything that it is required to be done. So if you do not have lawful excuse and you exercise your freedom of the press, and in exercising the freedom of the press, you contravene an act of Parliament, you contravene an order of the court, you contravene a regulation or an enactment, then you are guilty and you will be charged. But if you can produce a lawful excuse against the contravention of the Act of Parliament, then you have invoked habeas corpus. Okay, I'm going to go a little bit deeper here for those who have been following me for a while. In Article 127.1, disobeying an order of the court. Now, an order of the court, right, it's considered an act of Parliament, as we see in the Interpretation Act of Canada. The Interpretation Act reads as follows. Every provision of this act applies, unless a contrary attention appears to every enactment. Act means an act of Parliament. An enactment means an act or regulation. And a regulation includes an order, the court order, the order from the judge, a rule of the court, a proclamation, a bylaw, a resolution, or other instrument issued, made, or established. Disobeying order of court. Everyone who, without lawful excuse, disobeys a lawful order made by a court of justice or by a person or body of persons authorized by an act to make or give the order, is guilty of an indictable offense and liable to imprisonment for a term not exceeding 2 years, or is guilty of an offense punishable on summary conviction. Well, I order you to step back, and I order you to stop filming. What are you doing here, sir? I'm exercising the freedom of the press, and therefore I'm filming what's transpiring here. Okay, you're exercising the freedom of the press. You're standing as a statutory creature. There are operations of law. There are acts of parliament that allows a limitation and abridgment to be placed against your freedom of the press. Therefore, based upon that, I am ordering you to stop filming. I am ordering you to leave this area. Well, you're the one that claimed the freedom of the press. And you're the one that opened yourself up to the limitation and abridgment and to the charge against the statutory creature. You're not standing there under the freedom of the press. You are standing there under your right to liberty. You are doing what you are doing under your right to liberty. And that right to liberty, it brings forth your lawful excuse against the act of parliament or against the order of the person trying to enforce the act of parliament. So the onus, the responsibility is upon you to produce your lawful excuse. It is written already that a proper claim of right removes or ousts the justice, jurisdiction, or authority over the charge. If there is a proper claim of right in play and recognized, then it automatically produces the lawful excuse on the individual's behalf. Why? Because in that claim of recognition, you have already told them beforehand that everything you are doing from your full legal capacity. You are not operating as a statutory creature, and they do not have the right to force you into recognition as a person, as a statutory creature before the law. So when they try to apply their charges against you, you already have a document in play that produces an estoppel against them, that stops them in their tracks. It does not allow them to use the color of law or the color of right or to make an assumption that you are exercising freedoms, that you are standing as a statutory creature. Therefore, they want to apply their laws against you. It stops them in their tracks. Well, you owe a duty to the Act of Parliament. You owe a duty to these laws. That's what we're claiming. Oh, no, I don't. My claim of recognition told you, and my claim of recognition brought forth the ground that I owe no duty to the state. For my rights were not given to me from the state, but must be respected by the state. Thompson Newspaper Limited versus Canada. While individuals as a rule of law have full legal capacity by operation of law alone, artificial persons are creatures of the state and enjoy civil rights and powers only upon the approval of statutory authority. The individual may stand upon his constitutional rights. He owes no duty to the state. No duty to the state. And this works for the United States of America and for Canada. So you're out there, right, with your cameras. And they approach you and they're using the color of law. They're using the color of right to claim that you owe a duty to the state because you're a statutory creature exercising here in Canada the freedom of the press. But you're assuming and you're placing me into the capacity under Article 2 of the Charter. But I'm not standing under that article. I'm standing under Article 7, under my liberty. And therefore your color of law and your color of right is non-existent anymore. And if you operate as a Fifth Amendment auditor in the United States, if you operate freedom of the press in the United States, you need to have a claim of recognition already in play. Because if they push the point, and if they arrest you, and if they try to use the color of law against you, you already have a document in play that places an estoppel against them, that stops them in their track from going forward and charging you. And the same thing in Canada. If you're going to play that game, then you need to have a claim of recognition in play, because you break the color of law. You break the color of right that they are trying to use against you to charge you. You already have a lawful excuse in your pocket. And that document is your primary excuse. It's your lawful excuse that is brought forth to the justice to oust his jurisdiction, to remove his authority. Because you're not standing under a fundamental freedom. You're standing under a right. You're standing under a claimed right. And this will save you thousands and thousands of dollars in legal fees if you have to go to court and defend yourself. Because you will no longer have to defend yourself, but you will exercise your right under habeas corpus and remove the justice authority. So, my American and Canadian auditors, there is a way to defend yourself. There is a way not to be caught having to spend thousands of dollars upon lawyers' fees in order to try and defend yourself, which is to have that lawful excuse already in play, already operating on your behalf.